All right. Well, good morning, everyone. I want to welcome you to our coffee hour on this beautiful September morning and hope that everyone is doing well this morning. I want to welcome our guest, Jonathan Entin, who is a professor of law at Emeritus at Case Western Reserve School of Law and a repeat guest for us. Jonathan, we're so grateful to have you here. I'm Lynn Giacobbe. I'm the CEO here at Kendal at Home. And along with me today, I have Ryan Anderson and Sue Woitkin, who are both staff here at Kendal at Home. So I want to welcome you. And Jonathan, I was hoping that today maybe you could give us a little bit of kind of background on how we've gotten here today from Roe versus Wade to the Dobbs case and all of the anti-abortion issues that have come up in the last several months. And then let's open it up for discussion with our guests and get a little more information and just have a conversation about that. But I was hoping maybe you could give us a little background and share a bit about how we got here today.
Okay, well, first, thank you for inviting me back.
Thank you.
I'm glad to be here. I'm actually going to start a little bit before Roe to help set things up. Really, the Supreme Court didn't say a whole lot about reproductive issues for most of its history. There was a notorious case in 1927, Buck against Bell, which upheld a Virginia involuntary sterilization law. And perhaps the most famous line from that really strange decision from Justice Oliver Wendell Holmes was, "3 generations of imbeciles are enough." Carrie Buck was involuntarily sterilized, and the Supreme Court said that was okay. Then in 1942, there's a case called Skinner against Oklahoma. Oklahoma had a law that provided for sterilization of repeat offenders, but it exempted embezzlement and other kinds of, shall we say, white collar type crimes. And the Supreme Court said, well, even if it's permissible to sterilize repeat criminals, if you're going to do that, you have to have a uniform rule. You can't exempt higher class crimes. So Skinner's mandatory sterilization was blocked. Fast forward to 1965. A case called Griswold against Connecticut, which is a pretty significant foundation for Roe. Connecticut had a law that prohibited the use of contraceptives by anybody. And the Supreme Court, this was an outlier statute. Almost no other state had a law quite like that. But the Supreme Court said that this kind of law was unconstitutional because it interfered with the ability of married couples to decide whether and when to have children. And then there was another birth control case shortly before Roe, but Roe was decided in 1973, established that there was a constitutional right to privacy that allowed women, in consultation with their physician, this was a major piece of Roe, that a pregnant woman in consultation with a physician had the right to an abortion. Now, the court said that the countervailing governmental interests would become more powerful the later in pregnancy you got. The court endorsed a framework with trimesters, where in the first trimester it was very easy to get an abortion. In the second trimester, it would be somewhat more difficult. And in the third trimester, yet again, could be more difficult. But the trimester system basically said that the government could regulate abortion in different ways at different stages of pregnancy. Now, for all that we think of Roe as having been a polarizing decision, in fact, for the first several years, Roe had almost no impact on our politics. In 1975, when Justice Stevens was nominated to the Supreme Court, he was not asked a single question about abortion during his confirmation hearing. That obviously changed. And within a few years, we had people trying very hard either to get Roe overturned or at least to have it cut back. That continued into the early 1990s. In 1992, the Supreme Court decided a case called Planned Parenthood against Casey, which essentially reaffirmed the idea that the Constitution protected a right to abortion, although the court made it easier for governments to regulate abortion, changed the legal standard so that now only regulations that imposed an undue burden on abortion rights would violate the Constitution. But there was a lot of confusion about exactly what an undue burden was. And that led to a whole series of additional cases. And then really what happened was states began to compete for trying to get the Supreme Court to cut back on Roe or maybe to overturn it completely. That gets us to the Dobbs case. Mississippi adopted a law in 2018 or 2019 that prohibited all abortions after 15 weeks. It was clearly unconstitutional under Roe and Casey. Nobody pretended otherwise. And the lower courts made clear that this Mississippi law was unconstitutional, although some of the judges said, well, we don't like the fact that the Supreme Court has said that there's a constitutional right to abortion, but under what the Supreme Court has said, this law is clearly unconstitutional. The state brought the case to the Supreme Court, and initially it said, we want the court to rule on the question, are all pre-viability restrictions on abortion unconstitutional? That's what the Supreme Court agreed to decide when it granted review in the case in 2021. But when the case was actually argued in the Supreme Court, the state changed its argument and said, well, no, we actually want you, the Supreme Court, to overrule Roe and Casey and all those cases, all those other decisions that say that the Constitution protects a right to abortion. And that's what the Supreme Court decided on June 24th. Now, the decision is, you can count the votes in different ways. The vote to uphold the Mississippi law was 6-3. Chief Justice Roberts wrote a separate opinion saying that he would uphold the Mississippi 15-week ban, but that's all he would do. The other 5 justices in the majority, however, agreed that the court should overrule Roe and Casey. And that's what it did. This is the Alito opinion that was leaked in May, and then the final decision came down in late June. The final opinion looks very much like the leaked opinion. There are some changes, but not really of great consequence. And there are a couple of features of that opinion that I think matter a whole lot going forward. The most important feature is the theory, the legal theory that the court adopted. It's a very straightforward originalist idea. That is, originalism is an approach to interpreting the Constitution that says that the Constitution has a fixed and determinate meaning, and that meaning is the one that was fixed as of the time that the provision at issue was adopted. Nothing that happens after that time matters. All that matters is what this provision meant at the time of adoption. The relevant date for the Dobbs case was 1868. That's the year that the 14th Amendment was ratified. And that is the part of the Constitution that the Supreme Court used in Roe and Casey to say that the Constitution protects a right to abortion under the 14th Amendment that applies to the states like Mississippi. Now, interestingly, the originalist justices have some difficulty in agreeing on how to decide what counts for determining the original meaning. For example, in Dobbs itself, Justice Alito's opinion goes all the way back to 13th century English commentary and uses various other very old medieval and slightly post-medieval history. The court also says, the majority also says, that in 1868, not only do we have all of this English history, but as of 1868, no state allowed abortion. And therefore, as a matter of history and tradition, there is no abortion right. Now, that history is controversial in a lot of ways that we can get into, but it's notable that that Justice Alito and the other four justices who voted to overrule Roe and Casey took a pretty expansive view of history up to 1868, right, from the 13th century to a little past the midpoint of the 19th century. Now, by comparison, the court in June also decided a major Second Amendment case. And what's interesting about the court's treatment of history and tradition for that case was the court said, what really matters is 1791, when the Second Amendment was adopted. Justice Thomas, who wrote for the court in that case, said, well, yes, we know that there was some English history, and we even know that there was some colonial history, but that's not really important for our purposes. And Justice Thomas said, oh, and by the way, there's some post-1791 history of state regulation of firearms, but that's not really important either. In other words, the only time that was really important for the Second Amendment was 1791. Everything else was either too early or too late. In Dobbs, nothing after 1868 counted, but essentially everything before 1868 counted. Now, this isn't entirely a debater's point. As I said, there's a lot of controversy about the history that the court used in Dobbs, but it does illustrate that the idea that the Constitution had a fixed and determinate meaning is really a lot more complicated than some proponents of originalism might have you believe. So basically what happened is that the court in Dobbs says there's no constitutional right to abortion. Abortion regulations will be determined through the political process, that is, through state legislatures. They're close to the people. That's how things should play out. And by the way, whatever regulations they come up with, courts should be very deferential and essentially uphold pretty much anything that the political process produces. Now, there are a couple of questions that still we need to think about. For example, what about other kinds of constitutional rights that use this, or where the Supreme Court used reasoning similar to what it used to find a right to privacy in the Constitution that protected abortion rights? Well, I mentioned that Connecticut case, Griswold, the birth control case. Court used a similar kind of reasoning there. That might suggest that if the reasoning underlying Roe and Casey is flawed, that maybe the birth control cases are flawed. What about the right to same-sex marriage, which again uses similar reasoning? Well, Justice Alito in the majority opinion says, well, those are different from abortion. They don't raise the same kind of moral questions that abortion does, because abortion takes a life or a potential life, whereas contraception or same-sex marriage don't do that. So therefore, our opinion today doesn't really have any implications for those rights. On the other hand, Justice Thomas said, well, no, actually, if it were up to me, I would actually want to overrule those decisions as well, because they rest on the same kind of flawed legal reasoning that Roe and Casey rested on. Well, it's hard to know what to make of this. I mean, Justice Thomas is only one justice. It takes 5 votes to decide a case. And so far, at least, nobody is rushing to on the court is rushing to agree with him. On the other hand, Justice Alito's disclaimer isn't worth much of anything. It's not part of the actual decision. It's not a precedent. It doesn't bind the court. Sometime down the road, the court may have to address those sorts of issues, and it'll do what it's going to do. I would, however, suggest that if the court takes seriously the idea that the reasoning underlying Roe and Casey and abortion rights is flawed, that a lot more is up for grabs, or could be up for grabs, than just contraception and same-sex marriage. For example, in 1868, women had virtually no legal rights at all. So if we're going to use this kind of originalism that focuses on what did the 14th Amendment mean when it was ratified in 1868, then virtually the entire law of gender discrimination, or at least the entire constitutional law of gender discrimination, should be up for grabs. Now, I don't think for a minute that that's going to happen, but if we want to follow the logic, that could happen. More than that, if we take the understanding or the meaning of the 14th Amendment as of 1868, I think there's a real question about whether Brown against Board of Education, the great landmark case that outlawed segregated schools, I think there's a real question about whether that case was rightly decided as well. Now, I want to be clear. I don't think anybody on the Supreme Court or any serious legal analyst thinks that that Brown against Board of Education is really up for grabs. And I don't think that it's likely that anybody is going to press to unravel the entire law of gender discrimination. But I think it's at least a cause for concern that we're having this conversation at all. Sometimes we should be able to say some issues are settled. And while we might make philosophical points about whether they are settled correctly, as a legal matter, we should be at a point where some things should not be up for grabs every morning. And even if the court is prepared to reaffirm those things. Well, let me stop, Lynn, at this point and see if we can open this up for questions from you or from our audience so that we can get more folks involved. You're muted. Lynn, you're muted.
Sorry, I didn't click it hard enough, I guess. So what I was saying is, why don't we open it up for questions? And for those of you that have joined us today, if you'd like to ask any questions, I'm happy to turn your microphone on so that you can ask them. You don't have to type them in the chat, or I actually can let you into the program as well. So I'm going to invite folks to do that. Jonathan, I was wondering as you were talking and you were saying that while the other things may be up for grabs, it's not likely that would happen. A year ago, would you have thought that this would have been overturned?
A year ago, I would have been surprised that Roe would be overturned this quickly. My sense was that as we have seen a whole raft of abortion restrictions adopted by governments around the country, I would have expected the Supreme Court to follow the approach that Chief Justice Roberts was taking, which is let's just decide this case before us. What we have to decide, a kind of a narrow ruling, and I was expecting, and other analysts I think were expecting that the court would incrementally chip away at abortion rights. And then at some point, the court would say, well, now we have so eroded the foundation of Roe and Casey that it's time to do away with those cases. I mean, that's essentially what happened in Brown against Board of Education. The NAACP litigation campaign under Charles Houston and Thurgood Marshall began when the Supreme Court had said, well, segregation is clearly permissible. And so they brought a series of cases that undermined the doctrine. And finally in Brown, they said, okay, there really isn't enough left of this doctrine. Let's get rid of it. And that's essentially what the court did. And in a lot of ways, we were seeing the Mississippi law is kind of an example of that. In fact, some of the Ohio abortion restrictions are like that. The idea was, let's press ahead for as much as we can get, and eventually we will have the Supreme Court decide there's not enough of a foundation left. But basically, what seems to have happened is that that with the appointment of the three most recent justices under President Trump, all of whom in one way or another were pretty skeptical about the whole idea of abortion rights in the Constitution, there was, with the arrival of Justices Gorsuch, Kavanaugh, and Barrett, there was now a majority combined with Thomas and Alito who were prepared to go right now on the theory that they have the votes, why wait around, because who knows what would happen down the road. So yes, this was a year ago, what happened in June seemed like it would be a bit of a surprise, but we don't know exactly how things play out inside the court, and but it's pretty clear that at least on this issue, that these five justices didn't want to wait.
Right. It's interesting. I think, people don't recognize the impact their votes have, right? Because right now, I think I read this morning that more women are registering to vote in states where abortion laws have been enacted, and wanting to change the course of action. Do you think that the decisions are going to be taken away from the states, and that, if Lindsey Graham had his way today, we wouldn't have the authority in each state to make those decisions? What do you think is next?
Well, I don't know what's next. I mean, I was one of those many folks who got surprised at how quickly the court moved to overrule Roe in the Dobbs case. So I wouldn't rely on my political prognostication here. But I think that Dobbs, the opinion in Dobbs says, we want to return this issue to the states, let the people decide, or let the people's representatives decide. But there seems to be real pressure against that, and instead to have a kind of a national rule. Now, notice that President Biden and the Democrats are trying to legislate a national, pass a national statute that would protect abortion rights. Senator Graham, and probably at some point other opponents of abortion, are talking about passing a law that would that would prohibit or restrict abortion. And at this point, the political prospects for getting either type of law through Congress seem pretty slim. At least as long as we have the filibuster in the Senate, and as long as neither party has 60 votes, 60 member majority, it's likely to be pretty much impossible to pass a broad abortion statute through Congress. Again, assuming that we still have the filibuster, and that may generate some pressure. But it's hard to believe that at this point that any national statute is going to resolve the abortion debate. Roe didn't resolve the abortion debate, even though it wasn't intensely controversial for the first few years. It became intensely controversial, and remains so. Dobbs is intensely controversial, and so whatever the formal rule is, it just seems as though people who have strong views about whether abortion should be available and under relatively easily or relatively rarely, they're not going to be satisfied,
right,
really, until they get their way. And it's hard to see that either side is going to be able to persuade the other side anytime soon.
Yeah, it's amazing. I agree. It's hard to predict where we go from here and what happens. I want to open it up. I know folks, I've unlocked their microphone so they can talk. Carol, Stephen, would you like to join in the conversation?
Well, I will ask John how you see specific campaigns changing en route to the election based on candidates' concerns about how their voters are going to vote. Well,
one question that we need to think about, and it's really hard to assess. Yeah, as Lynn says, it seems as though a disproportionate number of women have been registering to vote in the wake of Dobbs. But we need to ask, and I don't have a way of assessing this very clearly, but we need to ask how much voters' views on abortion will determine the candidates for whom they vote in November. There are people who may be really upset with Dobbs for lots of reasons, who might think, well, abortion is important, but say the economy is also important. And although I'm really unhappy about Dobbs, if I can't pay my bills, then maybe I should vote for a Republican who maybe will promote sounder economic policies. So that's hard to tell. The other important factor here is that when you're talking about, say, statewide office holders like U.S. senators or governors, everybody's vote counts the same amount, right? Because everybody gets to vote for the governor, everybody gets to vote for the U.S. senator. When you're voting for members of Congress or for state legislators, they're elected by districts. And we're in Ohio, and we all know what a complete circus redistricting process has been for both Congress and the state legislature. Most of our congressional districts and most of our legislative districts are safe. It doesn't really matter who the candidates are. Certain districts are safe Republican districts and some are safe Democratic districts. And when you have that kind of gerrymandered system, the general election isn't really a meaningful check because maybe a strong candidate for the minority party in that district could pull a few extra percentage points. But if the district is, say, 60-40 in one way or the other, the majority candidate can afford to give up 5 percentage points and still get reelected fairly comfortably. So even if people are really exercised about Dobbs and they are going to vote on the basis of their views about Dobbs and about abortion more generally, that might not translate into very many changes in Congress or in the state legislature.
Wow. Stephen would like to ask a question. Go ahead, Stephen.
Hi, John.
Hey, Steve.
Hi. Just to go back a couple of minutes to what you said about the role of Congress. There was a op-ed, I don't know if you saw it in yesterday's Washington Post, by John, I think it's Uyoo, who argued that Congress lacked the power to enact either the Lindsey Graham prohibition or limitation on abortion or the Schumer legislation, as he described it, codifying the right to abortion. Do you have any reaction to the suggestion that Congress lacks power to act in this area?
I haven't seen that particular piece, but I've seen some discussion about whether Congress has that power, and there is some folks have questioned whether Congress has the power to codify abortion rights nationwide. And there would be two constitutional theories for such a statute. One would be under the 14th Amendment, Congress has the power to enforce the 14th Amendment's provisions by what is said to be appropriate legislation. The challenge to relying on the 14th Amendment to codify abortion rights is that the Supreme Court has said Congress may have broad enforcement power, but it can't go beyond what we, the Supreme Court, have said the Constitution means. So if under Dobbs, the Supreme Court has said the 14th Amendment doesn't protect the right to abortion, then maybe Congress doesn't have the power to pass enforcement legislation to codify abortion rights on that theory. The other main rationale for codifying abortion rights would be the Commerce Clause. Congress has broad authority to regulate interstate commerce, and the Supreme Court has generally, in modern times, has construed the commerce power pretty broadly. But the court has also said that that unless you can show some kind of substantial effect on interstate commerce, that there's not a that Congress doesn't have the power to regulate there. Now, I think that there are some ways that a statute that tried to codify abortion rights under the Commerce Clause could be written so that it might meet some of those objections. But I think the law would have to be written pretty broadly, or pretty carefully rather, sort of to touch, to punch the right tickets. It would have to involve more than just a broad declaration that this would have an impact on interstate commerce. Maybe there would have to be some language about people or things in interstate commerce, which the Supreme Court has also said would be a basis for federal regulation. Now, the argument for a national restriction on abortion, to some extent, maybe Congress could say, well, the Supreme Court has said that the 14th Amendment doesn't protect abortion rights, so we're going to use our enforcement power to underline that point, maybe. And a law that prohibits abortion might also be drafted again in terms of the Commerce Clause, like any person or any drug or any piece of medical equipment that crosses state lines cannot, that we can't do. In other words, what I'm saying is, I don't know what the answer to this is for sure. I do think that the current Supreme Court is likely to be skeptical of a federal law that would try to codify abortion rights. I think it would be more skeptical of that kind of law than of a law that purported to prohibit or restrict abortion. But I think, that's my view. It's a little wishy-washy, but I mean, I think that there are folks who have stronger views on these issues. And I think that the bottom line is the only way we're going to find out will be if one of these laws actually passes and then is tested in court. Right now, I think we are a very long way from getting any federal law through Congress. And I think that even if the Republicans gain control of both houses and they win the presidency the next time around, it's still not clear to what extent they can get such a law through. I mean, remember how many times the Republicans said we're going to repeal the Affordable Care Act, and they had enough internal divisions that they could never get it done. And we don't see this right now, but I think there really are internal divisions among Republicans in Congress about how far they want to go. And one indication about this is that a lot of Republican candidates in the general election are they're not very happy with Senator Graham. They don't want to talk about abortion. They want to talk about the economy, right? And because they think, at least in the short term, that abortion is a losing issue for them right now. So they want to change the subject. I don't know, as I said, I can't predict, but my hunch is that the current Supreme Court, as I said, would be more likely to strike down the Schumer bill than it would be to strike down the Graham bill.
Jonathan, can I shift gears just a little bit? And just, from a practical sense, many of my colleagues, I'm here attending a conference, many of my colleagues have, posted that they are changing HR policies so that They'll cover expenses for employees or family members covered under the health insurance plans to travel to another state in order to obtain an abortion, in situations where you're in a state that is, banning abortion.
Right.
What are the repercussions? Are there repercussions, potential repercussions for employers? What about the individuals that are traveling to another state and those abortion clinics that are performing the abortions for a woman who lives in a state where it's banned? Can you speak to that a little bit?
Yeah, that's a wonderful question, and it raises a lot of issues. And they're really issues that have less than completely clear legal answers. Okay, so let's think about this. In Dobbs itself, Justice Kavanaugh, who was a crucial part of that 5-member majority, said that he doubted whether a state could prosecute its own resident who traveled to another state to get an abortion where the abortion was legal. Now, if he sticks with that, and we don't know Chief Justice Roberts' position, but almost certainly the dissenters would agree that this would violate the right to travel. But the precise meaning of the right to travel is a little bit up for grabs, and I don't want to get too far into the weeds. Even if we say that Justice Kavanaugh, if we think that Justice Kavanaugh is right, that maybe Ohio could not prosecute someone who went to New York to get an abortion. That's your question suggests that that's only a small piece of the puzzle, right? In some states, take Texas with this SB 8, it's essentially the bounty hunter law that says anybody can sue any other person who somehow encourages or facilitates or participates in an abortion. Well, if you are in a state with that kind of law, and there are some other states that have gone down that path, and others that are thinking about it, well, there could be repercussions for the business, the employer who provides financial or other assistance to employees who go out of state to obtain an abortion that is legal there. So that's a potential problem. It may be more complicated for a state to actually go after the clinic or the hospital or the physician in the other state. So take, for example, the case of that 10-year-old Ohio girl who had to go to Indiana to get an abortion. I don't see how Ohio could prosecute the doctor, because the doctor was in Indiana. And there's been a lot of grandstanding by some Indiana politicians about they're going to go after that doctor, but it looks like she actually complied with all of the legal requirements for that one. I think it would be extremely difficult for a state to reach out to somebody in another state who was never in the home. So Ohio would have a hard time bringing the Indiana doctor here when the Indiana doctor wasn't in Ohio, and presumably did not do anything to reach out to anybody in Ohio.
Mm-hmm.
But again, it's not just the employer, right? There are all these other folks who might be at risk of a really aggressive state or local prosecutor who wants to go after them. So there is potential legal exposure. Now, it's also possible that if, say, a zealous local prosecutor decides to indict somebody, it's possible that a jury would not convict, right? But that's only small consolation. I mean, if you get indicted, that's already bad, right? It's going to disrupt your life. It's going to cost you money and all sorts of other things. So, I mean, that's not much solves. I mean, it's, you know, it's a very personal illustration of what I was saying earlier about the idea, well, you know, it may well be that the Supreme Court is not about to reconsider the Connecticut birth control case. But why are we having this conversation? Why should we be having this conversation? Now, sure, a lot of what we're hearing is grandstanding. Officials who think that there's some sort of political payoff for saying the right things and for looking tough on their position.
Mhm.
But that also means that they're probably not paying attention to a whole bunch of other more significant day-to-day issues, like if you're in Jackson, Mississippi, do you have clean water? I guess they finally do. But, you know, I mean, you know, Mississippi spent a long time grandstanding on abortion while the water system in Jackson was falling apart for years. And that, you know, that's another kind of diversion from the serious business of making sure that public services are provided on a day-to-day basis when people are paying attention to those sorts of things instead of just grandstanding.
Yeah. I think that's, you know, we see that happening all the time. I think, you know, even when you go back to you talking about, you know, all the issues that people are faced with, the economy, gun control. This is one of those, you know, top issues, but people have to make decisions based on all of that they're concerned about. So it's an interesting course of events in front of us, I think, as well as we navigate through this. It'll be interesting to see where we end up as a country on this issue. I want to open it up for any final questions that anyone might have. Do our guests have any other questions they want to ask? Well, thank you. I want to thank our guests for joining us today. Jonathan, thank you for taking time to join us again and just shed some light and help us to understand this complicated issue. I think it's so much more complex than I really ever understand, even understanding how we got here. So thank you for giving us some, shedding some light on that issue for us.
Well, thanks for inviting me.
Thank you. Well, we hope to have you back again soon. Maybe we'll be talking about this issue for a while to come, I'm sure. So thank you, and we wish everyone a great weekend. Thanks for joining us.